Good afternoon. I will now call the meeting of Special Committee on Reconciliation and Indigenous Affairs to order. My name is Lisa Semler, and I am the MLA for Inuvik Twin Lakes, the chair of this committee. Our first order of business is to opening our meeting with a prayer, and I will say the prayer. Heavenly Father, we ask you for your blessing and help us as we are gathered together. We pray for guidance in the matters at hand and ask that you would clearly show us how to conduct our work with a spirit of respect, joy, enthusiasm. Give us a desire to find ways to excel in our work. Amen. Our next item to review and adoption of the agenda, Madam Clerk.
We've done the prayer, review and adoption of agenda, declarations of conflict of interest, public matters, where we will have a presentation on the United Nations Declaration on the Rights of Indigenous People with Dr. Hayden King. And then we will go into camera following the presentation to discuss committee business, new business, parking lot, date and time of next meeting, and adjournment.
Thank you, Madam Clerk. Are there any additional additions or changes to the agenda? Seeing none, can I have a motion to approve the agenda as presented? MLA Johnson has moved adoption of the agenda. The motion is in order, and all those in favor? Are there any declarations of conflict of interest? Hearing none, I will move on to our next item. Today, the Special Committee on Reconciliation and Indigenous Affairs is receiving a public presentation on the United Nations Declaration on the Rights of Indigenous People. Our presenter is Dr. Hayden King of the Ryerson University. Welcome, Hayden. Today's meeting will be live streamed on the Assembly's social media channels, and presentation materials will be uploaded to the Legislative Assembly website following our meeting. To respect physical distancing requirements, several members and the presenter and members of the public will be attending virtually. And I will ask the members and the presenter to please wait to be recognized by the chair before speaking, and to direct all comments and questions and remarks through me. I will now ask the members to introduce themselves for the record, starting with the Deputy Chair, Mr. Johnson.
Alan Johnson, I'm the MLA for Yellowhead North.
Caitlin Cleveland, MLA Cam Lake.
Rocky Simpson, MLA Hay River South.
Kevin O'Reilly, Frame Lake.
Carolyn Cochran, MLA for Range Lake and Premier. Thank you.
Thank you, and I will now ask those who are joining us virtually, the members of the committee, to please introduce themselves.
Caroline Wozniak, MLA for Yellowknife South, the Minister of Finance, Minister of ITI, and Minister responsible for the status of women. Thank you.
Frida Marcellos, MLA for Tabacha.
Good afternoon, RJ Simpson, MLA for Hay River North, Minister of Justice and Minister of Education, Culture and Employment.
Thank you. I will now invite Hayden to introduce himself and to proceed with his opening remarks.
Thank you to the chair. My name is Hayden King. I come from Beausoleil First Nation on Chimnasing and Georgian Bay. That's a Anishinaabe community. I'm the executive director of the Indigenous Policy and Research Center Yellowhead Institute at Ryerson University. I'm happy to be here. I want to thank you for the invitation to make this public presentation. I've been doing analysis and presentations on the Declaration since I started my academic career in 2007. And if you had asked me then that we'd be here now discussing the domestic implementation of the Declaration, I think I would have been surprised. First, because it's taken so long, but in other ways, because I never really thought that we would actually be here and that this would materialize. So this is an exciting opportunity for me to talk through with you some of the challenges that accompany this legislation and some of the opportunities. I also want to say that if it's not obvious, I'm not Indigenous to the North. In fact, I come from one of the most southerly First Nations in Canada, but over the years have developed a lot of relationships with Indigenous and non-Indigenous folks in the Northwest Territories, and have had a chance to spend some time in Gwich'in, Dene, and Tlicho territories, and I wish I was there again. But I hope what I have to say here honors those relationships all the same. And finally, I would just ask you to forgive the lack of formality with my appearance in front of you today. I happen to be at my cabin this week, and the loft area where I am here under the insulation gives me the best internet reception. And I'm also realizing that my sweater matches my presentation color scheme, and I promise that that was not intentional. In any case, thank you once again, and I can begin my presentation.
Hayden, you can please proceed with your presentation.
Thank you. So this presentation is called UNDRIP and FPIC, or Free, Prior, and Informed Consent in Canada, Super Scary or the Status Quo. And I've chosen this title to reflect some of the discourse that surrounds the declaration that has been referenced by both of the previous presenters on the declaration. And I want to address both elements of the super scary, or maybe this is more of the same types of relationships that have always existed between Indigenous peoples and Canadians. And ultimately, I think I find that we're somewhere in between, though less on the scary side. In any case, if we go to the next slide, I can offer an overview of my presentation, which includes a timeline of the United Nations Declaration on the Rights of Indigenous People with some important context to perhaps correct a bit of the record on what has been presented already. Talk about some of the content, and in particular the contentious articles of the Declaration on the Rights of Indigenous People, the evolution of Canada's position on the Declaration, which is ultimately some more context for the discussion before us. And then get into some of the core elements of the existing domestic declaration laws. I think it's very helpful to consider the operative elements of both British Columbia and the federal legislation on the declaration. And I'll speak about some of the challenges that I and I think others see in those two examples that exist already, and how those might be overcome. And then finally, and this is a focus of my presentation, I'll assess the nature and the scope and possible implementation of this notion of consent, which I think is the element of the declaration that has been billed as the super scary part. So on the next slide, I have a very brief timeline of the Declaration on the Rights of Indigenous People, and you can see that there's a dramatic jump from 1493 into 2007 and towards the present. And I thought that it was really important to discuss the origin of international law, because often when we have these conversations about the Declaration, they happen in a vacuum, as if the Declaration was a sort of gift from states to Indigenous people. But international law emerged with this very racist doctrine of discovery that allowed competing empires, Spain and Portugal at the time, and then England and France, to legally claim lands that were occupied by Indigenous people and place those Indigenous people under the tutelage of the Pope, with, of course, the exception of any Christians. So in 1493, 1494, the very first piece of international law, the piece of international law that all international law rests upon, was this doctrine that permitted the colonization of the Western Hemisphere. And so when we think about these maybe more abstract questions, but I think pertinent ones, if you're Indigenous, certainly, about sovereignty and the origins of sovereignty. Canada has claimed that its sovereignty comes from this doctrine of discovery, that its sovereignty is established on the racist myth that Indigenous people had no governance, no law, no culture, and therefore were suitable for Christianization and their lands stolen. And that piece of context is, as I said, important because where we are today, talking about the Declaration on the Rights of Indigenous People and the turn away from those racist doctrines has been a 500-year-long struggle. And so when we discuss the doctrine, as I said, it's important to contextualize that. Now, throughout the enduring 450 years, Indigenous people resisted this doctrine, pushed back against empires, states, political communities that sought to dispossess us of our lands. Those efforts got a boost after World War II with the realization that minority populations were being suppressed by state governments. And the International Labour Organization, in conjunction with some, but very few Indigenous representatives, crafted the first international instrument on Indigenous rights, and that would become the Indigenous and Tribal Populations Convention. Now, the Indigenous and Tribal Populations Convention was drafted at a time when the United Nations was still young and the state as the political community was really privileged. And so the best way to protect Indigenous people's rights was to have them assimilate into the state. And so this convention was really about protecting Indigenous people until they could be assimilated. Obviously not a useful tool for Indigenous people. And so work really continued and was amplified throughout the 1960s and 1970s in what we would call today the Red Power movement, domestically in Canada, the United States, but also internationally. And it resulted in Indigenous representatives, advocates, leaders finding themselves at the United Nations, following in the footsteps of people that had been there long before, people like Descahe in 1923. And that organizing eventually convinced the United Nations and state governments to allow Indigenous representatives to make submissions and testify. And it resulted in the second international legal instrument on protecting the rights of Indigenous people, which was the Indigenous and Tribal Peoples Convention. Now, this convention did not get a lot of positive reception from states. In fact, very few states actually endorsed and supported the convention, primarily because it was a convention. And an international law convention is binding on states. Meaning that if, of course, they did not practice the guidelines set out in the convention, that the international community could sanction them in some fashion. So the Indigenous and Tribal Peoples Convention languished, although I should say that the language in that convention, to a very great degree, made its way into the draft Declaration on the Rights of Indigenous People. But those Indigenous representatives at the United Nations realized they had to change their course of action. A convention would not be accepted by states, and so they sought to pass a declaration, which is, in international legal terms, more aspirational and more fluid and something that states could work towards over time. That work culminated in 2006 with, as I said, a lot of language from previous international human rights instruments. However, it too was not received well by states, and 4 states in particular. And so from 2006 to 2007, there was a lot of conflict actually at the United Nations between Indigenous representatives and state governments. It led to protests, sit-ins, hunger strikes, because there was such an impasse about what should go into this declaration. Ultimately, states at the time were effectively able to win the day and have the General Assembly adopt a watered-down declaration in 2007, but they did so overwhelmingly in support. 144 countries voting in support, 4 against, and 11 states abstaining. And I think that this is important to note because Mr. Isaac had mentioned that very few states actually supported the Declaration on the Rights of Indigenous People at the time, and so Canada was not an outlier. The fact is, if we speak about facts, Canada was in fact an outlier, and perhaps the outlier. On the next slide, I can explain this a little bit more. Canada was part of 4 states, those 4 states that were collectively known as the Kansas Group: Canada, New Zealand, United States, and Australia, who organized together to push back against the Declaration and do that work of watering it down. And they worked together to dominate the agenda at the Human Rights Council. And since Canada was the only member of the Human Rights Council, they led the opposition against the Declaration on the Rights of Indigenous People. And the shift from the draft declaration in 2006 to 2007 resulted in fully removing 8 of the articles, amending 11 of those articles, and adding the extremely contentious, at least to Indigenous representatives, Article 46, which I'll talk about in a minute. Canada also helped to lobby African states to abstain from voting. So what ultimately made it into the Declaration? On the next slide, you can see that I have categorized them, and in fact, the United Nations has categorized them in this way, and I've just adapted their categorization. 17 of the articles focus on cultural revitalization. The preambular sections of the Declaration make it very clear that state governments have, throughout the course of the 450 years of colonization that preceded the Declaration, did their best to destroy Indigenous peoples and Indigenous institutions, including cultural institutions. And so the operative articles focus very much on this restorative element of revitalizing Indigenous culture through education, through language, through healthcare. And very much encourage the states in which Indigenous people live to direct resources to help in that cause. 12 of these articles focus on non-discrimination. And of course, we know, and Canada is not a stranger, every jurisdiction of Canada is no stranger to discriminating against Indigenous people. That discrimination, of course, continues in many ways. And so there is a heavy focus on anti-discrimination in the Declaration on the Rights of Indigenous People, while allowing Indigenous people to remain somewhat distinct in their self-determination. So the Declaration espouses this sort of dual citizenship model. And if there's a dual citizenship model, it's important for state governments to avoid discriminating using the discourse of, two-tiered legal systems and so on. 15 of the articles promote Indigenous participation in decision-making that affects their lives and their communities. And this includes 5 articles that reference free, prior, and informed consent to decision-making that affects their communities. And so the Declaration very much is about including Indigenous people and allowing Indigenous people the space and leadership to make decisions on, to self-determine their own future. And then finally, there are 6 articles that encourage states to offer redress to Indigenous people for assimilation policies and the loss of subsistence and development opportunities that have resulted from the history of colonization. And we shouldn't be too surprised at these articles because, of course, the Truth and Reconciliation Commission of Canada has very much put a focus on restitution as well, the giving back of what was taken. So I don't think I need to go through any of the articles in specific terms. I believe that this committee has done its due diligence on that already, though I would like to highlight 2 articles on the next slide that speak to the contentious nature of the Declaration, both from the perspective of state governments, and those 4 state governments, Canada in particular, as well as from Indigenous people. So the first of those contentious articles is Article 32. Article 32 is the free, prior, and informed consent article. Of course, FPIC appears in some of the other articles, but 32 references lands, resources, development. And of course, the Declaration encourages state governments and their jurisdictions to obtain the free, prior, and informed consent of Indigenous people prior to development that occurs on their territories. So this has been contentious for state governments, as we'll see as I move on to the next slide, but it's really been the holdup for state governments and Canada in particular over the intervening 10 years. Now, Article 46 is the contentious article from an Indigenous perspective. This article was added during that year of conflict. It did not appear in the 2006 draft declaration, but states lobbied for its inclusion. And so Article 46 basically says that nothing can be used in this declaration by Indigenous people that may authorize or encourage any action which would dismember or impair totally in part the territorial integrity or political unity of sovereign and independent states. So this passage, Article 46, and while it does have a softening element to it in the subsection number 2, basically allows states a backdoor out of the declaration, or at least I think that's how it can be perceived. If Indigenous people attempt to activate or operationalize any of these articles, if a state government viewed that action as negatively affecting the political unity, whatever that is, or territorial integrity, however defined, well, then they could push back against that. And this leaves interpretive power with the state ultimately. And that's not surprising, of course, because the United Nations is an organization that serves to represent state interests and state sovereignty. So, as I said, from an Indigenous perspective, the critical Indigenous voices of the Declaration on the Rights of Indigenous People will look at Article 46 and lament the fact that it has been added and allows states the wiggle room out of the previous 45 articles. So back to Article 32, because Article 46 is a subject for a later conversation, but Article 32 on the next slide, we can see Canada's more direct opposition in the consistency of their statements. So when the Declaration was introduced in the General Assembly, Canada's position was very simply that it violated Canada's Charter of Rights and Freedoms by putting Indigenous rights above the rights of other Canadians. And of course, in a liberal, multicultural society that Canada presumes to be, where everybody has the same rights, this was the discourse that was used to excuse the Declaration in a Canadian context. And that language proceeded from 2007 to 2010, and it was the Australian government of Kevin Rudd that figured out how to use Article 46 to interpret the rest of the Declaration. And Australia effectively said, you know, we're really concerned about free, prior, and informed consent, but when we proceed with this Declaration, we'll interpret that article through the lens of Article 46. And if we do that, then the Declaration is relatively benign. And so by 2010, the Harper government had taken the same line effectively and picked up the discussion of the charter, melded the two together, and said that we can make the Declaration work within the Canadian constitutional framework. By 2014, the statements against free, prior, and informed consent became that much clearer, despite the endorsement of the Conservative government when the Minister of Aboriginal Affairs at the time, Bernard Valcourt, was asked by Nunatsiaq News about free, prior, and informed consent. the response was that, well, it was deep skepticism that the declaration could proceed with that article. And so over the course of 2007 to 2016, we had these dual concerns from Canada. First, around whether or not the declaration is consistent with Section 35 and Canada's constitutional frameworks and concepts like equality. And this idea that free, prior, and informed consent would violate provincial and territorial rights to do what they chose with lands and resources, and therefore there was this irreconcilable barrier. Now, we know, and thank you for indulging me with this context, but we know that Canada's position has changed, and that's on the next slide. We can view the current state of the Declaration on the Rights of Indigenous People in Canada. A new federal government was elected, of course, in 2015, and fairly quickly removed objections to the United Nations Declaration on the Rights of Indigenous People. The Harper government had signaled its willingness to no longer oppose the declaration, but it hadn't formally removed objections. Minister Carolyn Bennett, Minister of what's now Crown Indigenous Relations, went to the United Nations in 2016 to remove those objections formally. And I should say that this was not simply a result of a new federal government, a new federal Liberal government, but also the work of the Truth and Reconciliation Commission, whose calls to action were able to generate significant public and national discourse, and the I Don't Know More movement before that. And of course, the Liberal government campaigned on a promise of reconciliation. And so in 2006, we started to see that change. Well, in response to the federal government's decision to remove objections, NDP MP Romeo Saganash introduced a private member's bill to ask the federal government to effectively put its money where its mouth is, and introduced a piece of legislation that has endured in many ways. We see it in the British Columbia legislation and the federal legislation, but it did not earn enough support in the parliamentary parliamentary system to become law. Effectively, it was killed by Conservative senators in the Senate in 2018, who used the same discourse that previous Conservative governments had in regards to concerns with the declaration. In 2019, the province of British Columbia, again campaigning on a promise of reconciliation, developed with an Indigenous leadership group a piece of legislation to implement the Declaration on the Rights of Indigenous People at a provincial level. That legislation would be called the Declaration on the Rights of Indigenous Peoples Act, or DRIPA. Implementation, it has been a year now, and implementation is ongoing. I'll speak a little bit later to the core elements of that legislation and where we're at right now. In 2019, the province of Ontario, at the provincial legislature, a private member's bill was introduced by NDP MPP Saul Mamakwa, modeled very similarly on Romeo Saganash's bill. It was endorsed by Parliament, actually, but when it made its way to committee, it has effectively stalled, and I don't think anybody expects it to be resurrected. In 2020, late last year, we had federal UNDRIP legislation introduced in Parliament. To a lot of, I would say, a mixed reception. Some very positive responses to the federal legislation, and some, of course, negative. It is in the parliamentary process right now, in the legislative process right now. Apologies, it's in past second reading and referred to committee. It's unclear if the federal legislation will pass. It still has to go through the Senate, and depending on whether or not there is an election in the coming months, it may not receive royal assent, so we'll wait and see. And There are a handful of other examples of the declaration being committed to at a symbolic level. This has been done by churches, by non-governmental organizations, by municipalities. In a northern context, that has happened as well. It's a little bit unclear what it means for a municipality to adopt the Declaration on the Rights of Indigenous People. So there is not much to say about those processes, except to say that at a symbolic level, at least, there is an increasing adoption by many elements of Canadian society of the Declaration on the Rights of Indigenous People. Now, if we consider all these efforts to implement the Declaration on the Rights of Indigenous People, what should they contain? What should those pieces of legislation contain for them to be effective? On the next slide, I have Cheryl Lightfoot, who is a professor of Indigenous politics and law at the University of British Columbia, and also a member of the United Nations Expert Mechanism on the Declaration on the Rights of Indigenous Peoples, her 4 suggestions for what's required in a declaration, domestic declaration law, or rather for UNDRIP to be implemented domestically. The first is federal enabling legislation. Dr. Lightfoot, I'm not sure if Dr. Lightfoot has written about provincial or territorial legislation. But federal enabling legislation will allow the declaration to be operationalized in a Canadian context. We've seen that happen, of course. Dr. Lightfoot also recommended the co-creation of national Indigenous action plans, figuring out how to implement the declaration once the enabling legislation has passed. The state governments would need to develop protocols for consent-based decision-making to satisfy that important FPIC provision throughout the declaration. And then finally, for there to be accountability in implementation, there would need to be an independent monitoring body to assess and review the progress on implementation. So how well have the federal and British Columbia UNDRIP legislation met this, what is effectively a test, I think you can say? Maybe they're not quite there yet, I'll say that. So if we can get to the next slide and look at some of the core elements of the federal legislation, we can see that there are a handful of legal obligations. The federal government has bound itself with this legislation to develop an action plan on the declaration's implementation. This has to be done in consultation and collaboration with Indigenous people. The goal is to take all measures necessary to ensure the laws of Canada are consistent with the declaration, and they have a 3-year window to make that happen. There is also a report to Parliament on UNDRIP implementation, and again, that requires consultation with Indigenous organizations. So how the federal government's legislation works is that the federal government will sit down with national Indigenous organizations and they'll develop an action plan for how they're going to bring Canada's laws in alignment with the declaration. And they have 3 years to do that. So the reception to the federal law, I think, among Indigenous leaders was this is far too long. 3 years is an incredibly long amount of time to wait for the federal government to develop an action plan, even with consultation. And others argued what we're seeing in British Columbia with the really glacial implementation process is that you really need that 3 years to get it right. So I won't cast a judgment on that particular argument at this point, but perhaps BC's legislation can be instructive to some degree. It is a long period of time, though. And then finally, after an action plan, after a year of the Declaration on the Rights of Indigenous Peoples being law, the federal minister must report to Parliament on the actions that have been taken. And they have to develop this report in consultation and collaboration with Indigenous people, or in the federal law, Indigenous organizations. Now, the core elements of the British Columbia legislation on the next slide are very similar. There are two differences. Before I talk about the differences, I'll just say that the legal obligations are the same. Developing an action plan on UNDRIP implementation with Indigenous leadership, making sure that British Columbia laws will come in alignment with the declaration, reporting on the progress of implementation. Now, there isn't a 3-year window on developing that action plan. That's the first difference. And then the second big difference is that the DRIPA legislation in British Columbia has empowered Indigenous governing bodies, that's a legal term, with decision-making authority, and actually statutory decision-making authority, so that those Indigenous governing bodies can enter into agreements with Cabinet and make decisions about British Columbia legislation. So that doesn't exist in the federal government's legislation, and again, at the time of British Columbia's legislation, was seen as a pretty powerful tool to bring Indigenous people into the discussions around how to bring BC's laws into alignment with the declaration. So I think that on the former difference around the action plan window and not having some time and space to develop that, we are a year into British Columbia's legislation, and implementation is painfully slow. I think you can look to people like Judith Sayers for analysis and comment on this process, but effectively the work has not been done in this case. So when we look at these pieces of legislation, we can expect some implementation challenges. And on the next slide, I have laid out some of the challenges that I think we can expect if they are not already here. The first, and you'll note that in Lightfoot's test for implementation, neither the BC or the federal government's legislation has an independent monitoring body. And so in that sense, they fail that test. So the result of not having an independent monitoring body will be disagreement on what implementation means. We see this already with the Truth and Reconciliation calls to action, where Indigenous governments, leaders, community members believe that, let's say, only 8 of the Truth and Reconciliation calls to action have been implemented, whereas the federal government believes that 3 times as many calls to action have been implemented. And there is no tool or metric to determine how to measure progress independent of these 2 siloed approaches. And so we can expect, very likely, without an independent organization or body to assess the progress, that we'll continually have this interpretation gap on what progress means. And that will lead to conflict. I think it will be difficult for British Columbia and the federal government to have widespread support of the Indigenous partners when it's time for them to report on the progress. Second, there is not yet clear a process for aligning laws with the declaration. British Columbia, because they're a year in, and maybe because they developed the legislation with this in mind, is a little bit further ahead by creating these joint decision-making bodies. But the process for how new laws, when they're introduced, will come into alignment with the declaration is not clear, nor is the process for how the volumes of law that exist prior or that were introduced, passed, became law prior to the declaration will be amended to come into alignment with the Declaration on the Rights of Indigenous People. So a big question is, can, let's say, the province of British Columbia pass a piece of legislation if there is no process for aligning laws? Can they pass a piece of legislation that Indigenous people disagree with and can that become law without some intervention with the courts? So that's unclear, and that will be a challenge. And so it's very important to figure out what the process is for this alignment of laws. In the BC context in particular, the pace of implementation to date has been very, very slow. I've already made this point, so I don't think I need to repeat it, though I suppose there was a theme in Mr. Isaac and Mr. Frame's comments around making promises and not being able to follow up on them. I do think to a degree that is happening in British Columbia because of the slow pace of implementation. That's not to say that it can't be mitigated. It's not to say that the process can't be expedited. It simply requires the political will to do so. A fourth concern might be around the absence of community voices in the process of drafting the legislation. I think that already there is an emerging response at the community level to the federal legislation that they don't necessarily think that the Declaration on the Rights of Indigenous People is all it's cracked up to be, and might actually be a Trojan horse to erode Indigenous rights, inherent rights, or Section 35 rights. And that skepticism, that caution has come about because the federal government has not engaged those community voices and instead worked solely with the national Indigenous organizations. And so that perhaps is a criticism as much as it is a caution. And related to that, there is a lot of legal confusion, especially in the community, among whether or not the Declaration on the Rights of Indigenous People will be subjected to, will be subsumed under Section 35 of the Constitution. Of course, you all know Section 35 is that section that affirms Aboriginal and treaty rights. Well, again, I'll disagree with one of the previous presenters, Mr. Isaac, on the golden standard of Indigenous law in Canada. Section 35 is relatively, I shouldn't say relatively, it is deeply conservative. It affords Indigenous people very few rights. We have rights to hunt, trap, and fish effectively, and recently rights to be consulted on development that affects us. But otherwise, Section 35 is very, very narrow. And the concern is, does UNDRIP legislation become subsumed under the existing interpretation for Section 35 rights, which would effectively hollow it out? That's a question for a legal scholar, an Indigenous legal scholar, of which one I am not. But it is a concern and one to consider as you go down this path. I think that another concern to be conscious of could be jurisdictional confusion in regions and across the country. If we have federal legislation, provincial, territorial, regional, municipal, First Nation, Indigenous commitments to the Declaration on the Rights of Indigenous People, how will we ensure the process and the content are harmonious? And I think that this matters more specifically to northern jurisdictions where the legal framework is a little bit more masonous than, let's say, a provincial jurisdiction. And that should be considered. And then finally, and this is where I'll move into the final part of my presentation, the ongoing debate around consultation versus consent. So we have heard from 2007 onward that free, prior, and informed consent will not be something that Canadian officials are willing to accommodate. Instead, consultation is effectively a stand-in for consent. And Minister Bennett has said as much prior to the introduction of this federal legislation that we already have concepts of free, prior, and informed consent in the duty to consult. But that is not the case. The two concepts are different. And so I would like to briefly go over that difference and then talk about consent in a little bit more depth, if you'll afford me a few extra minutes on my presentation. So on the next slide, we have the basic overview of the duty to consult, which I know that you all know very well, so I don't need to expand on it in great length. I will say, though, that Mr. Isaac's concern about Indigenous people having rights to lands that Indigenous people have occupied, used, or otherwise, meaning the entirety of Canada would fall under the realm of Indigenous rights, well, that already effectively exists with the duty to consult. So I think it's important not to be misled that the duty to consult applies to established or asserted treaty rights. And all of Canada is under an established or asserted treaty right. Therefore, the duty to consult applies to all of Canada. It is not a stretch to accept that a concept like consent would also apply to all of Canada. I don't believe in the type of alarmist rhetoric that would have legislators be afraid of the declaration on those grounds. Indigenous rights encompass all of Canada, inherent, constitutional, however you slice them, and that is a matter of fact. And of course, we know that the duty to consult varies if it's a community that will where a transmission line crosses the border of their territory. The consultation might not be deep. Of course, if you're building a pipeline across caribou calving grounds, then it will be intense, of course, and in fact so intense that it borders on consent. And I think the important point to remember about the duty to consult, and this is where the distinction is between consultation and consent, is that even if an Indigenous community opposed a development that were to occur on an established or asserted treaty right, or harm an established or asserted treaty right, that development could still proceed. It could still proceed if the project was in the public interest and the Crown's fiduciary obligation it was not violated, and the First Nation, Inuit, or Métis community was consulted to the degree that was required. So that's the important distinction. And I will say, as we move through time and Indigenous assertions of jurisdiction become louder and more forceful, it is, I expect, even without the Declaration on the Rights of Indigenous People legislation at any level or jurisdiction, it will be harder and harder and harder, if not impossible, to proceed with development in cases where Indigenous consent have not been obtained. Even if the case law and even if Supreme Court decisions do not explicitly say development cannot proceed without consent, Indigenous nations will make that so, I believe. So I want to move towards consent now, and perhaps make consent less scary than it has been described in discussions around the Declaration on the Rights of Indigenous Peoples to date, whether by federal officials or whether by casual commentators. So on the next slide, I have the first of a handful of examples of consent as it has operated in the Canadian context already. So I don't want to spend a lot of time going back to 1609 and talk about the Turo Wampum or the Goswenta, or 1701 and talk about the Great Peace of Montreal, or even the Royal Proclamation of 1763, or any of these historical agreements. But Canada was effectively founded, or rather I should say emerged out of Indigenous legal protocols requiring consent. So some of those very first treaties with non-Indigenous peoples, those people, the English, the French, the Dutch, they required the permission, the consent of the Haudenosaunee, the Anishinaabe, to settle the land, to exploit the resources, and to enter into relationships with Indigenous communities. And so Canada, at its origins, as I said, abided by consent protocols laid down by Indigenous people. This was recognized by the English in 1763, perhaps Canada's founding document, the Royal Proclamation of 1763, laid down Indigenous land rights and recognized Indigenous sovereignty, to the extent that some legal scholars have called the Royal Proclamation the Indian Bill of Rights or the Indian Magna Carta. Effectively, if the English wanted to cross the Great Lakes and settle lands west of those lakes, they would have to get the permission of the Indigenous nations concerned before they could do so. Again, consent. Not to say that the Royal Proclamation wasn't also a very deeply colonial proclamation. It was, but it did recognize Indigenous land rights all the same. Pre-Confederation and numbered treaties, which of course extend into the Northwest Territories. The Indigenous signatories in all of those treaties believed that they were maintaining their jurisdiction to lands. And while Canadian officials later had a different opinion, nonetheless, those visions of consent were embedded in early treaties. In a more contemporary focus, we do have consent in at least one piece of federal legislation. And on the next slide, you'll see a passage of the National Energy Regulator Act. And this is consent on a reserve context. So effectively, the federal government has prohibited companies from building a pipeline or taking any related activities to build a pipeline, infrastructure, etc., across reserve lands without the consent of the Band Council. So, I mean, this is obvious, of course. Well, maybe not so obvious given the history of the Indian Act, but this is the first time that consent appears in federal legislation. And it's in 2019, and Canada has come close in subsequent legislation, not quite again yet, to getting consent in a piece of federal legislation, but I think it could be a sign of more to come. So that's on reserve lands, and if it applies to pipelines, I think you could effectively make the case that it applies to other areas of development or activity. On the next slide, you'll see tidal lands. And here, the situation is not as clear cut, of course, but we know that in 2013, the Supreme Court of Canada recognized that those who still hold title to their lands and can prove that they have title, the threshold of consultation is so high that it is effectively consent. Now, the Supreme Court did not say you can infringe on Aboriginal title. You certainly can if you're the Crown or whether provincial or federal. But set the standard so high that it is quite near consent. And in fact, they use the language of consent. The former Chief Justice of the Supreme Court has spoken about the importance of consent in the pursuit of reconciliation. So this has been a thread, though not picked up explicitly since the Chilcotin decision in 2013, that consent on tidal lands is becoming increasingly the expected practice. I should soften my language around that. Consent is the best practice, I should say, in relations between the Crown and Indigenous people on tidal lands. Now, the federal government also has a new negotiation approach, a new approach to negotiating Aboriginal rights, title, and self-determination. This is in the federal rights recognition and self-determination tables, and Mr. Frame spoke about open mandate negotiations. We're starting to see that. And we have two MOUs, two agreements, one with the Heiltsuk and one with the Wet'suwet'en from 2019-2020, which do not spell out consent explicitly in them, but I believe are approaching both the Heiltsuk and Wet'suwet'en in specific areas having exclusive decision-making powers in certain areas. So we're starting to see not only the Supreme Court move towards consent, but we're starting to see federal policy move towards consent. And I hope to see more of this to make this case more forcefully. But there are shades of consent, at the least, on tidal lands. On the next slide, this is type of consent that is not recognized by any federal, provincial, or territorial jurisdiction. But another variant of, no, that's a bad word, another type of consent is one that is led by Indigenous people themselves unilaterally. So these are cases where Indigenous people have said, this is our land, this is our jurisdiction, we have our own laws, and we are going to enforce our versions of consent on development or provincial activity. And so we've seen this in Ontario with the Niskandaga Development Protocol, which has a free, prior, and informed consent element. We have in Quebec the Kitigan-Zibi Moose Moratorium just last fall, that prevented Quebec moose hunters from going in and harvesting moose without their consent. Saking First Nation in Manitoba has developed a consent protocol and enforced it actually with numerous companies. Saugeen Ojibwe Nation worked with the province of Ontario and convinced both the Ontario government and the Nuclear Waste Management Organization that any discussion about burying nuclear waste in their territory would require the community's free, prior, and informed consent. Ultimately, after a referendum, they decided they would not proceed, and that decision was respected. They enforced their vision of consent in this case. The Chilcotin have used their title declaration to enforce consent around a handful of resource development areas. Admittedly, mushroom harvesting is not gold or platinum mining, but the Chilcotin are issuing permits around mushroom harvesting, and this is a form of free, prior, and informed consent as well. And then finally, perhaps most provocatively, but not uncommon at all, are Indigenous community members who are putting their bodies in the way of pipelines or mining developments and are enforcing their visions of consent in more direct ways. And I think a lot of Canadians will look at these examples and see them as, breaking the law. But from an Indigenous perspective, and I wouldn't presume to speak on behalf of the Sipwet'mek or the Wet'suwet'en or anyone else, but from an Indigenous perspective, I think you can assume that those communities are enforcing their own law. And so while they may seem provocative, they are, in fact, required. So finally, I want to talk about consent in a modern treaty context, which is the next slide. And this, is there consent in a modern treaty context? I think to a great extent, the answer is unclear. Obviously, on settlement lands, there are not going to be Crown land use decisions that are made without the consent of the First Nation, Métis, or Inuit consent, if they're made at all. And I think that is in some ways a powerful indication that consent can be normalized. And then in the regulatory regime, I don't think you could make a forceful argument that consent exists here, but there are a handful of examples through co-management resources boards, land use planning boards, the regulatory regime in the Mackenzie Valley Resource Management Act. Indigenous participation in decision-making is embedded, and in cases where territories in particular stray from the commitments that are made to Indigenous decision-making, Indigenous communities take action, and that results in, I think, a pretty powerful argument towards an Indigenous form of consent. And we could look at examples of the Peel Watershed Land Use Plan. We could look at the proposal for the NWT Super Board, which the Tlicho and others were able to stop. The Inuit of Clyde River preventing the territory from permitting seismic testing in violation of, again, a modern treaty. And again, I'm not sure you could call these examples consent in any fulsome way, but perhaps you could say that they are de facto consent. And I guess this is an open question as well. It's one that I haven't been able to consider at length, and I don't presume to be an expert on the regulatory regime in the Northwest Territories, but the Mackenzie Valley Resource Management Act is federal legislation. Could it be would it be one of the laws that has to be aligned with the Declaration on the Rights of Indigenous People? I don't know the answer to that question. So moving on to the final slides here, I don't think I'll go through this to any great degree. You'll have my PowerPoint presentation and you can review it, but you can see that there are a number of assumptions about where consent comes from a community perspective, from a Crown perspective, and from a court perspective. You can see what would be required of a consent protocol from each of these perspectives, the horizon in terms of the timeline for consent. Each of these differ a little bit from a community interpretation to a Crown interpretation to a court interpretation. But I think what you can say, and what I can say after developing this presentation and working through these different interpretations of what consent is, that the concept is emerging and it is becoming practice, not quite at the level of, custom by any means, but so much so that you can discern a certain interpretation of what consent is from communities, from the Crown, and from the courts. And I think that that's a powerful signal that free, prior, and informed consent is not, in fact, something to be afraid of in the way that it has been characterized. So finally, on the last slide, how could you operationalize free, prior, informed consent? Well, there are a few process options there are a few process options that have been attempted and a few that have been proposed. So through the Declaration on the Rights of Indigenous People legislation, there could be a cabinet committee. The federal government tried to do this with its quote-unquote decolonizing committee to bring all new laws in alignment with the Declaration on the Rights of Indigenous People. That failed, ultimately. In BC, we have the Joint Cabinet Indigenous group that has not quite got to consent protocols, but that's another process. And there are other proposals for a secretariat to coordinate all the various entities, parties, governments, treaty organizations, etc. Those that don't have treaties, modern treaty or otherwise. Working groups, leadership tables, etc. And then processes outside of the Declaration on the Rights of Indigenous People legislation. The duty to consult right now is triggered through impact or environmental assessment processes. Well, consent could also be triggered through those same processes. Modern treaty implementation, I think, from someone that works with those close to modern treaty implementation, especially around the lands and resources elements, I think you could pretty plainly say that implementation is a problem here. And that would require, of course, federal government and territory working with modern treaty holders to figure out consent protocols through implementation, if that potentially could be an option, but it doesn't cover those who do not have modern treaties again. Another process outside of the UNDRIP legislation is adversarial processes like the courts, which is basically what we use right now to determine consultation and, to some degree, consent. And then finally, there are Indigenous-led assertions and enforcement, which I talked about briefly already. And I think on this last point, I'll just say that this is not going to stop as a trend. I think that you will see, as Indigenous communities, organizations, governments continue to grow in power and with resources, that asserting and enforcing consent will be a reality independent of any Declaration on the Rights of Indigenous Peoples legislation. And I think that that's an important point to note. I think that consent as a concept unlocks a lot of the challenges in our collective relationship. It unlocks the challenge around self-government. It unlocks the challenge around land rights, and it unlocks the challenge around the contentious relationship that we have as Indigenous people and non-Indigenous people. So we can spend all our time trying to pass, rights recognition, implementation legislation to affirm Indigenous self-government. We can continue working on modern treaty implementation, but at a national level, at least, and I hope I'm not so bold to say at a territorial level, consent is a key that could unlock those persistent challenges that we face. And so I'll leave my presentation there, and I'm happy to try to answer any questions or hear any comments that the committee has, and have a discussion about anything that I've said. And yeah, thank you very much. Miigwech.
Thank you for your presentation, Hayden. I will now allow questions or comments from committee, and I'm going to start with our committee member that's on the phone, Ms. Martselos. Did you have any questions or comments?
I just want maybe I could be last this time, okay? I was first again last time. I'd rather comment last. Thanks.
You're welcome. So I will go to Mr. Simpson, who is virtual with us. Did you have any questions or comments?
Thank you, and thank you very much for the presentation. I know you mentioned Mr. Isaac a few times, and this was as sort of a contrast to that, where we talked a bit about how to as opposed to why we can't, which is what I'm really struggling with. I think that the big difficulty is that, as you stated, Canada, the authority of Canada, a lot of that it's really rooted in the doctrine of discovery. And you can follow the line from that up to the Supreme Court cases that talk about consent. So one of the big challenges is there's that view that the Supreme Court has authority, and that's rooted in the doctrine of discovery. And then there's another view that I hear from Indigenous governments, Indigenous people, that isn't rooted in that. And so it's people are starting from two different places, and I find it difficult to get to the same place from there, because you read the text of the declaration from one view and from another view, and it doesn't mean the same things. And I don't think that in the territory we're afraid of consent. I don't think that's our problem. I think it's really the practical implementation. How do we make this work? And part of it is that we have a number of Indigenous groups, and it takes a long time to get things done. It takes a long time to get things done as government, and then the consultation and the consent of everyone is, as you said, painfully slow to achieve. So I guess more comments than anything, but it's really that the practical on the ground implementation that I'm still struggling with after these last few presentations. But thank you very much. I really appreciate your insight. Thanks.
Thank you, Minister Simpson. Hayden, did you want to respond to his comments?
Sure. I think that the point that you make about dual interpretations is a chronic condition that we have faced in Canada. So, you can trace this back to the Royal Proclamation on 1763. There were two different interpretations of what it meant. The treaties that came out of the Royal Proclamation in the Great Lakes area, where I'm from, there were two interpretations of what those treaties meant through the numbered treaties. And I think even to a degree, you see it with modern treaties, especially the lands and resources elements, where there's a disagreement about what certain sections of these agreements actually mean. And so this interpretive challenge is a long-standing one. I think a more critical perspective could make a very strong case that this has been a malinterpretation by the Crown and Canadian provincial territorial governments. But effectively, that's that's what we're all trying to do, is to figure out how we can achieve consensus on moving forward together. And that's a very reconciliatory approach, I suppose. But I think that there are alternatives to that as well. And the alternatives to that are an adversarial relationship, a contentious relationship that we have endured and will continue to endure. When it comes to the practical on-the-ground implementation of consent, I think that one of the big challenges that we have is around political will. I'm not going to say that there's not an incredible degree of complexity. I know that consensus takes much longer to achieve when there are many voices at the table. But political will goes a long way to expediting these types of processes, and perhaps that's just not what we see in the British Columbia context. Certainly not when that jurisdiction has been beset by provincial and actually federal-wide protests around the building of a natural gas pipeline contravening their provincial declaration legislation.
Thank you. Did you have any further comments or questions, Minister Simpson?
Thank you. And yeah, I see what, I get your point about there being two interpretations of everything. It's something we just have to overcome. And the idea of consent as well is it's complicated by the fact that we have a territorial border, or there's provincial borders that really are arbitrary in terms of Indigenous governments as far as they're concerned. And now all those Indigenous governments that happen to be in that geographical area that we say are one territory or one province are expected to all consent, or have similar goals to projects, and maybe the project will negatively affect some groups and positively affect others. So it's just, it's obviously it's endlessly complicated, and I'm not here to make a presentation, so I'll just stop right there and then hand it back. So thank you very much for indulging me.
Thank you, Minister Simpson. I will now go to MLA Johnson.
Thank you, Madam Chair, and thank you for your presentation. Yeah, I guess where I see implementation kind of getting stuck is whether we or anyone's going to fit this into Section 35, and that seems to be the persistence from almost every lawyer I've heard, and most governments, that we have to remain within the constitutional framework of Section 35. And I guess my concern with that is it turns Section 35 into a bit of a ceiling as opposed to a floor. And I think I appreciated what you were saying about Section 35. It's an inherently conservative section that deals with a small bundle of rights and forces the entire conversation to be, was it meaningful consultation? Which, to me, Section 35 is just a long way from consent. And I guess to frame that comment into a bit of a question for you is there anything out there that's preventing us from going beyond Section 35 and saying, listen, in the Northwest Territories, we no longer consult, we just seek consent, and the beginning of the conversation is you have a veto. If you don't want this to go ahead on your traditional territory, then it won't. And I think that just fundamentally changes the relationship. Every conversation, knowing that there is actual consent, becomes much more trusting and builds that relationship. And we've done it, in a lot of cases with settled areas, and I don't see why we can't just, in the territory, be the first to say, yeah, it applies to the entire Northwest Territories. But perhaps I could get you to speak to that kind of limitations of Section 35 or the constitutional framework we find ourselves in. Thank you.
Thank you, MLA Johnson. Hayden, did you want to respond?
Yeah, I can try. I think that, and you heard it in the presentations already, there's these two interpretations of Section 35. It's either a full box of rights, and we can't put anything else in it. What's in there, that's it. Or it's an empty box of rights, and we can continue to put rights within the box. Now, the courts have defined the duty to consult and, to a lesser extent, consent in the absence of legislation. So the Supreme Court of Canada has laid down what consultation is, principles of consultation, and again, to some extent, consent, without having any legislation to interpret. And I think it's an open question around the court's role. If the NWT, or Canada for that matter, were to introduce legislation that recognized the consent of Indigenous communities in decision-making that affects them, the court is going to interpret that. And it's going to interpret it based on case law. It's going to do all that work. And so it's an open question. But ultimately, as legislators, as lawmakers, you are well within your bounds to create any law in NWT context. And if somebody disagrees with it, a judge will determine whether or not it violates the Constitution. And that test has not been, that path has not been tread. But if you were hypothetically to design a UNDRIP legislation that included elements of consent, that would be your prerogative, and it would be for a court to decide if there were a conflict down the road, whether or not it conformed to the various constitutional sources or not. But I believe the people that help you draft legislation, the legal experts, are, I believe, inherently conservative themselves, but would help advise you on how best to do that to avoid any potential court challenges in the future.
Thank you. I will now move to Minister Wozniak.
Thank you, Madam Chair, and thanks very much for your presentation. I'm sorry we're interrupting your time at your cabin, so thanks for taking the time out of the day. I'd like to understand more, and I actually wanted to say, I acknowledge, you're saying you're not a legal scholar, but I'm actually glad to not have a legal scholar here. I'm glad to have a scholar of politics. I think that's actually a relevant and important perspective. But the question I'm going to ask you, I'm saying that because the question I'm going to ask you is, do we even need a law here? Like, do we actually even need a law if for the four elements of effective implementation that you described, aside obviously from the enabling part, which is obviously speaking to a legislation, but the three others, I don't know that we need a law to achieve them. And similarly, with respect to the elements of operationalizing consent and the examples that you gave there, again, we don't necessarily need a law to achieve them. And, and maybe we do, but that's my question is, what would be the benefit of putting these things, whether it's the effective implementation elements or whether it's operationalizing consent? Is there a benefit to putting in a law, or are we providing ourselves an excuse of saying, here's our gold star, we're good, thank you? Are we creating unnecessary delay? Or maybe there's some good reason for doing it. So, thanks.
Thank you, Minister Wozniak. Hayden?
Yeah, I think that I don't know the trajectory of your career. I don't know the trajectory of any of your careers, how long you'll remain at the legislature, but you will have successors, and they may or may not disagree with the policy that you lay down regarding consent or regarding the Declaration on the Rights of Indigenous People more generally. And so how a law helps is to bind the government. And to bind the government's actions. And I don't mean that in a way of, I don't mean that in the same sense of, fettering you that may have been expressed in a previous presentation, but rather to hold yourselves accountable. Without legislation, it's much more difficult to more fully commit to and be accountable for those commitments. And see the actual realization and implementation of the legislation, because you can do it through policy to some degree, but I suspect its life would be limited.
Thank you. Minister Wozniak, did you?
Yeah, I guess then it becomes though, if we then say that we need the piece of legislation, and it's a piece of legislation that's supposed to be about consent, does it not, that piece of legislation itself, need to already be created through the process by which we're describing? Like, does it not does that law not itself need to come from a place of co-creation and co-drafting in order to actually be meaningful?
Thank you. Hayden?
That's an excellent question, and it's the heart of the consultation debate in the Canadian context today. In the New Zealand context, they've done that exact approach. So instead of starting with the federal legislation at the with cabinet, they have instead created working groups that are sort of Indigenous and government officials to develop the scope and content and justification and rationale, et cetera, of legislation before they proceed with an actual piece of legislation. Now, in a Canadian context, I think if Minister Lametti were here, he would probably tell you that there was a lot of consultation and collaboration with the national Indigenous organizations to before that legislation was introduced federally in this context. And I would assume, and again, I don't want to be presumptuous, but that you'll have Satu, Gwich'in, Dene, Tlicho people coming and speaking to this committee as well. And so I suppose the question is, how deep does that consultation need to be for you to be comfortable moving ahead with legislation and not having the sort of community opposition that might emerge otherwise?
Thank you, Hayden. I will now move on to Madam Premier.
Thank you, Mr. King, for your presentation. It's always good to hear from people. Nice to see your cabin. Nice to see your shirt matching your presentation. What I'd like to say is I think you're a little bit familiar with the NWT, but I'd like to explain a little bit about the NWT as well. We're quite different than the South, in fairness. We have what's called an intergovernmental council, which I'm one member of. It's not unilateral, it's not the GNWT overseeing. We are equal members at that table, and every Indigenous government and the GNWT are members, except for two that wouldn't sign on to devolution because they believe their relationship was with the federal government. So in order to address those two governments, we also have two other tables. We have a modern treaty table, which I just came back from this morning. And we also have a multilateral table, which has all the Indigenous governments, whether they're devolution, sign-on, or modern treaty, or in the process. So we take the work very seriously. Within our Intergovernmental Council, I'm not sure if you're aware, we just recently did a legislative protocol that any legislation around land and water will be, I'm not even going to say in consultation because I'm not really keen on that word. It's what do you think, and I'm going to do what I want. So that will be in partnership with the Intergovernmental Council and working with the Legislative Assembly as well. I beg to differ. I think that if any governments after us tried to take that legislative protocol off of the table, they would get a huge fight from the Indigenous governments. They have quite a bit of power in the Northwest Territories. But my question is around, we are trying to look at the implementation of United Nations Declaration. It is one of our priorities of this government. But I'm struggling with it. I've got three different places with the Indigenous governments here. We have some that have no self-government agreements and aren't willing to get there at this time. They're not willing to do that. And they voiced that they don't need self-government anymore. United Nations Declaration is going to be the answer, and that's what they're going to focus on. And then I have a second set that are in the process, quite a few actually, that are in the process of negotiating self-government agreements. And they're saying, like, what are we doing? We spent years and lots of money and resources and energy, and all of a sudden we might just have to throw this out and United Nations Declaration is going to be the answer. And then I have the modern treaty, which I just met with today, and they are not liking this. They're saying that Article 37 out of the United Nations Declaration is what we need to do. They're talking about, trying to take words from them. They said So I heard clearly from them that the implementation of the modern treaties is their preferred approach to reconciliation, and that our focus should be built on the existing collaborative relationships we have and fully implementing the current agreements. They're worried that this whole idea around the implementation of the United Nations Declaration is going to be viewed by people as a distraction that'll take away from the important work of treaty implementation. So I think my difficulty is in saying that is, like I said, we're in a different spot in the Northwest Territories. We are trying to collaborate with, having legislation protocol around land and water is huge for all of us. And we'll look forward to doing more as we work forward. What would be your recommendations around how do I deal with this when I have three different groups? A sect that has their agreements in place, modern treaties, another sect that is in the process, and then the ones that aren't looking at it and saying, we don't need it now, we're going to go with the United Nations Declaration. How do I address that? Thank you, Mr. King.
Thank you, Madam Premier. Hayden, would you like to respond?
Yeah, I mean, I appreciate the anytime I can get an education on how the dynamics work in NWT, and will be the first to admit that I am not an expert in the politics in your communities, and so in that sense, I'm hesitant to even attempt to answer the question. But the legislation can apply to some groups and not others. That's one route that can be taken. It's again, I don't want to speak. I don't want to say something that my modern treaty holder colleagues are going to say, Hayden, why did you go to that committee and tell them that we needed the Declaration on the Rights of Indigenous People legislation when we just need our treaties implemented? But consent doesn't appear in modern treaties. I think that's clear, and so I only see the Declaration, while I could see the argument that it is a distraction from implementation of modern treaties. Absolutely, I don't really see a disharmony there. I see UNDRIP legislation as being a tool to complement modern treaty legislation, or self-government for that matter. But again, I think there are better people to ask that more specific question than me.
Thank you, Hayden. Madam Premier?
Thank you, Mr. King. I'm going to try to ask you a little bit easier question. There's no such thing as easy. I'm setting you up. So I'm getting a bit of there's two trains of thoughts here, and within the House I'm getting a little bit of a push by members saying, get the act done. I'm hearing you say that the act is really important to get it done. But I've read the United Nations Declaration a couple of times, and I keep flipping back to it. I have it now, and I'm flipping back to it. And what sticks out for me very clearly is this is about Indigenous people, and it is for Indigenous people to say how this will be. And I've used that argument in the House to push back members and say, back off. I'm not going to implement it. It's very colonistic. If we as members say this is what it shall be. And now, so I'm sitting at the table with the Indigenous governments, the Modern Treaty Group, still haven't met with the multilateral on their opinions, but the Modern Treaty Group is saying to me, we're not looking at that legislation right now. We want to go through it article by article and identify where we work together on those things. So I'm hearing you say that the act is important, and yet I'm hearing the Indigenous governments at the Modern Treaty table saying they don't want that. What do I do with that? Thank you, Mr. King. That's your easier question.
Thank you, Madam Premier. Hayden?
Sure. Where should I start with trying to answer this question? I think that the federal government and the British Columbia government's legislation is what is called enabling legislation. So the legislation does not say all the articles of the United Nations Declaration on the Rights of Indigenous People are going to be implemented in our jurisdiction when we pass this law. Rather, it's enabling legislation in the sense that it enables those articles to be implemented in those specific jurisdictions. So if you were hypothetically, again, to draft a piece of legislation that was similar to the British Columbia or federal legislation, it would be the first step in then figuring out what articles apply in an NWT context, which articles don't, and how government would work with the various Indigenous groups to conceptualize, operationalize, implement, measure the progress on all of those specific articles. And I think that the federal government and the province of BC designed the legislation for that reason, though the advocates of the Declaration on the Rights of Indigenous People will critique that approach for not going far enough. I think they took a very politically smart move to satisfy some of the very same concerns that you express here. And I think that is a possible solution to the impasse. But at the same time, I can't speak on behalf of those who would want to take a more circuitous, longer path to really fleshing out what the declaration means in an NWT context and passing legislation immediately. I think that there are different approaches for different settings. And just to clarify my presentation or my argument in the presentation, I think that, consent is this really important key to the relationship moving forward. Consent is going to unfold whether governments in any jurisdiction wanted to support it or don't. And the Declaration on the Rights of Indigenous People legislation is one path towards recognizing and implementing consent. So that's the part that's important to me. The declaration legislation on itself is not important to me. It's just one path. And if I were giving a presentation to my Indigenous friends and colleagues, I might say be very careful about the GNWT passing a piece of UNDRIP legislation because it could be co-opted. And there's a Yellow Knives Dene scholar that I'm not sure you'll be hearing from, but I'm sure you're all well aware, Glenn Coulthard, that talks about this type of co-optation. When Indigenous rights get recognized by governments, they can be manipulated, regulated to the harm of Indigenous people. And Dr. Coulthard has made that argument very loud and clear. And I suspect that Indigenous organizations, governments, communities, people are aware of it as well. And perhaps that might be driving some of their skepticism. So I hope that wasn't too rambly of an answer, Premier, but that's what I have on those very tricky questions.
Thank you. I will now move on to Ms. Martselos, if she's on the line there.
I am on the line. Thank you, Madam Chair. First of all, I want to thank you, Dr. King, for your presentation. I think the one question that I would have is regarding Section 35, clarity on consent. So in your presentation, you mentioned that, say there was a development that was going to happen, say, just for an example, on reserved lands. Especially, I guess I'm thinking about reserved lands, but any lands, whether it be lands that were designated for Métis use, when they finished their claim in the territory here. Under Section 35, the clarity on consent, does that mean that the government can still go ahead with the development even if they do not get, if the Métis or, say, the Salt River First Nation do not give consent? Could you just clarify that for me, please? Thank you, Madam Chair.
Thank you, MLA Martselos. Hayden, would you like to respond?
Yeah, so I can try. Currently, consent is not a Section 35 right. And so if development were to proceed against the consent of the Métis or Salt River or whatever other community, the consent is not a requirement. It's not a constitutional requirement. It's not an obligation on the Crown. And so that development would be able to proceed. Of course, it would have to go through the environmental assessment process, consultation, and if it was a significant development, then it would require significant consultation. But consent, no. Although, as I tried to make an argument in my presentation, I think that is where we're headed, or at least the tools are being developed for First Nations, Métis, and Inuit to be able to deploy their interpretations of consent. Now, if the federal government were to include consent in their legislation, which they didn't, but if they were to, then it could be open for consideration about whether or not that was a Section 35 right. I realize that that's not a very clear answer, but this is completely new terrain for Aboriginal law in Canada, and I'm not sure that there is a clear answer to that. As Mr. Isaac said, and a point that I will agree with him on is Aboriginal law in Canada is dense and complex and subject to multiple interpretations. And I believe if there were federal legislation that recognized consent, that would go the same path. So again, that's a tricky question to answer, and I don't know if I've done it. But at the moment, consent is not a Section 35 right.
Thank you for your response. MLA Martselos, did you have a follow-up?
Yes. Thank you, Madam Chair. So if it's Section 35 is not a consent, and that is why there's always this, nothing's binding with any level of government, especially the federal and even with the territorial government. And so that is a big concern for Aboriginal groups because government likes to, we always have to challenge the government in court, and that takes forever. It's just slowing down the process in the interest of government instead of the interest of the First Nations. And that's a concern because, as a former leader for 12 or 13 years of an Aboriginal group, and that is a great concern. So that's always been in the back of our minds. You settle a claim and you're in the implementation phase, and every single word is analyzed and redone over and over again. And if you want to challenge it, it's always by arbitration. It's always by something. And so the Aboriginal people are the ones that always are at the losing end of the stick. Would you agree? Thank you, Madam Chair.
Thank you, MLA Martselos. Hayden, would you like to respond?
Yeah. Now, the courts, they are tired of making rulings around the duty to consult. They're tired of it. They don't want to do it anymore. And so they have said numerous times, governments, get your act together, develop these consultation protocols, they don't say develop consent protocols, but, like I said, I think maybe there's space to go in that direction in the court. Certainly Justice Veal's Peel watershed decision went in that direction. So courts are tired of making these decisions on behalf of governments and Indigenous people. They say, and we all know, it's extremely lengthy, it's extremely costly, and they want negotiated agreements. With the federal government over the past 5 years, we have started to see that with the rights recognition framework, the rights recognition and self-determination tables. But by and large, courts want negotiated agreements. Now, to answer your more direct question, are Indigenous people always on the losing side of these agreements? I think, there is nothing that would, I shouldn't say that, but the Métis or any of the communities that you represent, they can develop their own consent protocols. They can represent their own consultation protocols, and they can do their best to enforce those protocols. And they might have a partner in the government, or they might not have a partner in the government. But that's Indigenous jurisdiction, and we're seeing more and more of it. And I expect that trend will continue, so that, in some ways that may lead to less contentious discussions and debate with governments. It may lead to more. But as I have tried to make the case in this presentation, I think that's the direction that we're headed, and it'll be up to governments to decide how to respond.
Thank you, Hayden. I will now move on to MLA Cleveland.
Thank you very much, Madam Chair. Madam Chair, so just, I guess, further to what the Premier had said, just about the landscape of the Northwest Territories, and she has a much different perspective and that I would ever have, because I don't sit at the same tables as her. But we do have an interesting and I think quite beautiful territory where we have 33 very distinct communities, and when something happens in one community, there's an impact in another community, because we're all connected in the Northwest Territories. But even though we're all connected, our communities are also very unique, and we very quickly learn by discussion through our colleagues that one size fits all doesn't necessarily work very well in the Northwest Territories. And so when I think of the United Nations Declaration on the Rights of Indigenous People, I'm looking at it more from a policy perspective and a systemic perspective of what this means as far as housing, and what this means as far as healthcare and education across the Northwest Territories. And so on slide 12, when you started talking about independent monitoring bodies, it caught my eye and my attention as far as what this potentially would look like in the Northwest Territories when you're talking about items at more of a policy level. Because a lot of times we find that policies maybe are written or updated by people who live in Yellowknife, and they don't necessarily work well for people who live in Toledo or live in Ulahaktuk. So I'm wondering if you can speak more to what that effectively could look like in the Northwest Territories to be as efficient as possible and effective here. Thank you.
Thank you, Emily Cleveland. Hayden, would you like to respond?
I can provide a partial response. Again, not trying to presume to know the NWT policy and legal landscape, but provinces have auditor generals. We have ombudsmen for all kinds of social policy areas. In fact, we have an ombudsman for business and Canadian businesses operating outside of the country, and these are effectively offices that hold those companies or businesses accountable for the actions that they take when they're outside of the country. And the Auditor General role, very similarly, holds governments accountable for programs that they commit to developing and delivering, along with the spending that accompanies them. And I think that the concept of an independent monitoring body falls along those lines. An independent body, independent from government, at the most perhaps an arm's length agency that has independence, that will be able to assess whether or not the GNWT is fulfilling its commitments that have been made under the Declaration on the Rights of Indigenous Peoples legislation. And so, as I said, an Auditor General model perhaps could be effective with a specific focus on this legislation, or even more broadly, something that the Royal Commission on Aboriginal Peoples has called for, and to a lesser extent the TRC with the National Reconciliation Council. A body that would hold governments accountable, an independent body that would hold governments accountable for their commitments to Indigenous people generally. So not even specific to a single piece of legislation, but just across the board. And the TRC argued that was a critical component of reconciliation, because otherwise, again, we have the opportunity, and we see it manifest in government policy every day, where there's a difference in interpretation of what progress is, what success is, what's been implemented and what's not been implemented. In a modern treaty context, that's an ongoing debate. So having that independent body in social policy areas would go a very long way to hold governments accountable for their commitments.
Thank you, Hayden. Seeing that you don't have a follow-up, I will move on to MLA O'Reilly.
Yeah, thanks, Madam Chair. My previous speaker, my colleague from Cam Lake, just stole my question. So, look, I'll try to put a little bit different flavor on it because I've spent about, well, a good part of my adult life here working on independent environmental oversight. You know, we've got these oversight bodies for the 3 diamond mines. One was set up for the giant mine remediation, and I helped negotiate that agreement. So I'm familiar with the concept for, say, an environmental project, but I'm trying to figure out how this would work in terms of Indigenous rights and implementation of rights. You know, you mentioned an ombud, the Auditor General, as potential sort of models, and the importance of public reporting. We've got some dispute resolution mechanisms in the modern treaties, of course, through you know, arbitration panels that can be set up to deal with disputes. So I'm just trying to figure out, is that something that you would suggest needs to be built into UNDRIP implementation legislation if we go that route, or that it becomes part of the dialogue, the negotiations in terms of some of the fora that the Premier talked about? There's different multilateral forum and so on. Does dispute resolution have to be part of that, and how does independent oversight and public reporting fit into those kinds of functions? Thanks, Madam Chair.
Thank you, MLA O'Reilly. Hayden, would you like to respond?
I don't think that there is anything that would prevent legislation in the Northwest Territory context from referencing, as you say, some of the other mechanisms, tables that already exist as a form of accountability. I don't necessarily think that you have to create something brand new if it's something already exists. Though, if you were to pass legislation, declaration legislation, that there would have to be an infrastructure built around those existing forums for accountability. But the other things that you mentioned in terms of public reporting, those would all be critical features of an independent monitoring body. And one model could be simply a forum for Indigenous communities, individuals, even families, organizations, governments, treaty, or and on to submit submissions to that ombud, and that ombud would then investigate them and rule on whether or not there was a specific violation of the UNDRIP legislation. Of course, that would also be done in the courts to some degree, but that's yet another model. But I don't think more complexity helps the situation. And if you are able to use existing forums that work for accountability, then it seems to me that you have the power to amend those forums when it comes to the declaration legislation.
Thank you, MLA O'Reilly. Did you have a follow-up?
Thank you.
MLA Simpson, and then I'll back.
Thank you, Madam Chair. And I'd like to thank you for that presentation. It kind of reminds me of being back in law school. So, but anyways, I guess it's interesting, and I guess as you were talking, I'm thinking about the Indian Act. I'm thinking about modern treaties and UNDRIP as well. And I guess being involved in this for a number of years, and I've seen the number of distractions that have come through, and that have been put in front of us as Indigenous peoples. And so I guess the question I would have is, then how do you see, one reconciling, like trying to move modern treaties ahead versus, taking some of that time and spending it on trying to, negotiate and accepting and the implementation of UNDRIP. Will that, I see it taken away from what we've been trying to achieve for a while. And is this the time to do it now, or is it something we should look at, down the road? Thank you.
Thank you, MLA Simpson. Hayden, would you like to respond?
Sure. Again, I can try. I think not every Indigenous person is covered by a modern treaty in the NWT context, and so I suppose that's one element to consider. And the other is around the commitment to implement modern treaties and maybe some form of consent, if that's what modern treaty holders actually want. Because if you are not going to proceed with Declaration on the Rights of Indigenous Peoples legislation, if I were a modern treaty holder, and again, I don't mean to be presumptuous, if I were a signatory, if I were a member of those communities, I would want to say, okay, well, if you're not going to proceed with this Declaration on the Rights of Indigenous People because we prefer to have our actual agreements that already exist implemented, show me your commitment to do that. And so I don't know if that's an answer to your question, but I suppose that there are gaps in the Northwest Territories in terms of those covered by modern treaties and those who aren't. And what would be a signal to modern treaty holders that there's going to be the political will to move towards full implementation of modern treaties if not having accompanying legislation like the Declaration on the Rights of Indigenous People.
Thank you. Did you have a follow-up, Mr. Simpson?
Yeah, thank you. And I appreciate that response. I guess, when I look at it, and we've got treaties in place, we've got modern treaties in place, throughout Canada, and now we're looking at implementing and something new. And I guess my concern or my question would be is, what impact will that have on the modern treaties? Does that mean that you see us having to go back to what we've already negotiated and make sure that we're not taken away from the treaties, or do we have to give something extra to those modern treaties to make sure the two mesh? Thank you.
Thank you, MLA Simpson. Hayden?
Yeah, this is a very, in some ways, complex question, and I suppose in other ways pretty straightforward. The likelihood of amending modern treaties is very low, I think. However, any future declaration legislation would be in addition to what already exists in modern treaties. So if there are obligations in modern treaties to recognize the substantive Indigenous decision-making powers in the regulatory regime, et cetera, those remain. But of course, there's nothing in those treaties that explicitly says that Indigenous consent is required to proceed with development on non-settlement lands, for instance. So you would have the modern treaty provisions, and this is again sort of hypothetical based on how you would draft the legislation, but you'd have the modern treaty provisions, the elements, those would be unchanging. But then the legislation that was drafted, if it did include a process to develop consent protocols, would be in addition to that. So the complexity comes in when you think about trying to organize all the various organizations, governments, and communities, and developing the consent protocols independent of modern treaty processes. So I don't know if that answers your question, but I think maybe in more straightforward terms, I highly doubt going back and amending modern treaties, and that this legislation would exist in parallel to them.
Thank you. Before we wrap up this public session, I will give Madam Premier, she has one last question.
Thank you, Madam Chair, for the generosity. Thank you, Dr. King. I think I'd called you Mr. King, and I correct myself. You're a doctor, and I respect that. I am keen on oversight. Again, in the Northwest Territories, there's, I think about 55% of us, more than half of us, are actually Indigenous in the Northwest Territories, various Dene, Inuit, Métis, etc. I think that's it, Dene, Métis, there's no etc. However, and the majority of our Legislative Assembly is also Indigenous. So being Indigenous, I take to heart the self-government agreements. When I was in university, that's when I first learned about self-government agreements, and ever since then, many years, I've been carrying it close to my heart. But I heard about the oversight, and I want to make sure that I'm not setting up Indigenous governments to fail, because like you say, there will be others after me, getting older, so there will be younger people hopefully coming and taking my spot. Or maybe older, I don't want to offend anyone. However, right at this point, so I want to make sure that I'm not leading people in the wrong direction. So this morning in our modern treaty table, one of the treaty governments has offered to do a template, a draft template for all of the modern treaties to be able to evaluate the implementation of the modern treaty agreements. And so this morning we agreed to let them do the work, and then all of us would look at that draft. So I don't want to set them up and think that this is okay if it's not. Are you saying that we should still have an independent body aside from that? Or should we allow the modern treaties to develop their own template, recognizing they have probably as much, if not more, lawyers than we have in the GNWT as well? I don't want to make a mistake, and I do not want to do something to go backwards or to do what is not my intent with the self-governments in the Northwest Territories. So that's my question. Do I need more than just the modern treaties evaluating themselves? Do I need to present that to them, or do you see that that is something that might suffice? Thank you.
Thank you, Madam Premier. Hayden, would you like to respond?
Yeah, I think, when it comes to modern treaty implementation, we have these organizations that have emerged, like the Land Claims Coalition of Canada, to try to push federal and territorial provincial governments towards implementation. The federal government created a new deputy minister to try to shepherd implementation. But there does not exist a body to hold governments to their implementation commitments. And in fact, what happens is we go to court instead. So any forum that's created and empowered by a government to hold government accountable for their commitments, I think, is a powerful tool. I don't know enough about the framework that you're describing to comment on whether or not something additional would be required, but I think that I would say it sounds very clear to me that the complexity you're describing might mean multiple processes for multiple communities or collections of communities, and that diversity is a reality. So I think that the federal government and the British Columbia government do not have references to independent monitoring bodies. It's a recommendation made by an expert, Dr. Cheryl Lightfoot, on UNDRIP implementation. But beyond that, there's very little guidance. And so it's really up to you to sit down and discuss those who are interested in this legislation to figure out if what you have is appropriate and sufficient, or if it's not, and more is required. But I wish I could be more helpful in my response than that, but that's all I have.
Thank you. If there are no further questions from committee, I would like to ask Hayden if you have any closing remarks.
Just that I've been happy to spend some time with you here today. I think that this is a really challenging area of policy and law. And I think it's probably more challenging for this group of leaders and Indigenous partners than in other parts of the country. And so it's something that I'm sure you'll approach with care and diligence and mutual respect. And I wish you well on those efforts, and hope that you're able to find a path forward that leads to a place of justice for Indigenous people and non-Indigenous people too. So that's it. Miigwech, thank you very much.
Thank you. So I'd like to take the opportunity to say thank you for your presentation today, and please stay on the line with us. To those who have tuned into the live stream, enjoy the rest of your day, and this concludes the public portion of our meeting. And we will take just a couple minute break here, just while